With that, I will begin with House Bill number House Bill number 5127, sponsored by Representative Edith Ajello. It is an act related to health and safety, the Reproductive Health Care Act. It codifies the current state of the law on reproductive rights in Rhode Island by incorporating the protections set forth in Roe v. Wade, limiting the restrictions on an individual's decision to terminating a pregnancy. Representative Ajello, welcome.
Thank you, Mr. Chairman and members of the committee. It is good to be here tonight, and I want to first thank the chairman, Representative Craven, Representative Shanley, Representative McEntee, Representative Almeida, Representative Canario, Representative Casimiro, and Representative McKiernan, all members of the committee who signed on as co-sponsors of House Bill 5127, the Reproductive Health Care Act. There have been a lot of misconceptions spread around about what 5127 seeks to do. I hope to disabuse you of some of those if you have misunderstandings. It is not an extreme bill. It is simply aimed at putting in Rhode Island law, which is what is currently effective law in Rhode Island. Because I've heard so many inaccurate claims about 5127, I'd like to first go over the Rhode Island statutes that are explicitly not to be abrogated in 5127. To abrogate, I looked it up in Google this morning, to abrogate is defined as to abolish or annul. So on page 2 in the list of laws not to be abrogated, 5127 would not abolish 11918, which requires medical professionals to provide adequate medical care to an infant born alive during an attempted abortion. That would not be annulled or repealed. 5127 would not abolish 1154-1, which prohibits experimentation on human fetuses. You may have heard that fetuses would be sold, or body parts would be sold for experimentation. 5127 would not abolish 1154-1. 5127 would not abolish 23-4.7-1, which requires informed consent for abortion, or 23-4.7-2, which requires written consent, or 23-4.7-3, which requires certain disclosures, or 23-4.7-4, which deals with emergencies requiring immediate action, 23-4. It would not abolish 1154-1, which prohibits experimentation on fetuses. 5127 would not abolish 23-4.7, also which requires informed consent for abortion. 23-4.2 requires disclosures. 23-4.7-4 deals with emergencies. 23-4.7-6 requires parental consent or judicial bypass. For individuals under 18, 23-4.7-8 deals with physician liability, and 23-4.7-9 deals with the severability piece of this abortion statute. 5127 would not abolish 23-13-21, the Comprehensive Reproductive Health Services Act, which specifically excludes abortion from Medicaid coverage. 5127 would not abolish 23-17-11, which protects healthcare providers who refuse to participate in abortion procedures. 5127 would not abolish 42-157-3 Part D, dealing with the Rhode Island Health Benefit Exchange, which requires that at least one policy at each benefit level exclude abortion. We missed in writing 5127 one law. Mr. Chairman, I would like in a substitute A, to add 23-4.6-1 to the list of state laws not to be abrogated in 5127 on line 7. This very new state law that allows minors over 16 to give medical consent in emergencies explicitly excludes that consent for abortion. We should have added that, missed it. And I think it makes sense to add 18 U.S.C. 1531, which is the federal so-called partial birth abortion law, which has been found constitutional. So I think it makes sense to add it in the list of statutes not to be abrogated. Now I'd like to talk about all of the unconstitutional and/or unenforceable laws 5127 seeks to abolish. Beginning on page 2, line 14, we would abolish 1131 through 1135. This law is the law against induced abortion, passed in March 1973, 2 months after the U.S. Supreme Court Roe decision. It was immediately unconstitutional. Please note on page 3, line 4 of 11.3. On page 3, line 4, the language, human life commences at the instant of conception, and that said life at said instant of conception is a person within the language and meaning of the 14th Amendment of the Constitution of the United States. That's in that law 11.3 that we need to get off the books. It's been found unconstitutional. It was never enforced. It has no place in our laws.
Lord help us. Yeah.
Beginning on page 3, line 16, 5127 would abolish 23-4.8-1 through 23-4.8-5, which is the spousal notice for abortion. This, too, has been found unconstitutional. Certainly, in healthy families, women will share their personal decision with their spouse. This statute could do nothing to, as it states, promote the state's interest in furthering the integrity of the institutions of marriage and the family, as its introductory sentence states the purpose to be. In a healthy family, a pregnant woman will discuss important decisions like this with her partner. Beginning on page 4, line 16, 5127 would abolish 23-4.12-1 through 23-4.12-6. This is Rhode Island's partial birth abortion law, which passed in 1998 and was found unconstitutional because it vaguely describes an abortion procedure which could be taken to be the most common abortion procedure in the second term of pregnancy. That's before fetal viability and therefore protected by the Roe decision. I would note, as I did earlier, there is a federal partial birth abortion law, 18 U.S.C. 1531, passed in 2003, which has been found constitutional and is therefore law in Rhode Island. Beginning on page 5, line 34, 5127 would repeal or abolish Rhode Island's antiquated quick child law. It has not been enforced and has conflicts with the Roe decision in its definition of fetal viability. On page 6, beginning on line 14, 52127 would repeal 27-18-28, which prohibits health insurers from providing coverage for abortions except to protect the life of the mother or in the case of rape or incest, except as an optional rider with an additional premium. That, too, has been found unconstitutional. Beginning on page 6, line 33, 5127 would repeal that portion of 36-12-2.1, which prohibits health insurance benefits for public employees and prohibits coverage except for the life of the mother, rape or in rape or incest cases. The courts have concluded that this law cannot be applied to city and town employees. So 5127 would repeal that language regarding municipal employees. And finally, beginning on page 7, line 18, dealing with Right Start coverage for pregnant women, would add cases of rape or incest to saving the life of the person as exceptions to the prohibition on abortion coverage. This change is in line with the federal Hyde Amendment. Now I'd like to go back to page 1 and slowly go through what 5127 seeks to do, besides the not to be abrogated and the repeal. 5127 says that the state shall, and any of its agencies or subdivisions, none of those, shall restrict an individual person from preventing, consenting, commencing, continuing, or terminating that individual's pregnancy prior to fetal viability. Interfere with an individual's decision to continue that individual's pregnancy after viability. Restrict an individual person from terminating that individual's pregnancy after fetal viability when necessary to preserve the health or life of that individual. You may have heard on the radio or elsewhere about this legislation allowing abortion right up to the time of delivery. I'll repeat line 13. This legislation shall not restrict an individual person from terminating that individual's pregnancy after fetal viability when necessary to preserve the health or life of the individual. That's all. Goes on to talk about restricting medically recognized methods of contraception, restricting access to medically recognized ways of practicing contraception or doing abortions. It defines fetal viability as that stage of gestation where the attending physician, taking into account the particular facts of the case, has determined that there is a reasonable likelihood of the fetus sustained survival outside of the womb with or without artificial support. Mr. Chairman, members of the committee, I think that the Supreme Court was very wise in the Roe decision. They didn't say that abortion access couldn't be restricted up to a certain point in a pregnancy, because medical science is advancing, and fetuses born prematurely, infants born prematurely, are kept alive successfully at earlier stages in the pregnancy. I don't know, none of us know where that stage will be sometime in the future. So having the legislation not say so many weeks into a pregnancy or in this trimester and not that trimester, but saying when the attending physician concludes that the fetus is not viable, abortion is all right. And it's talking about medical procedures. I hope That's all clear. My intent clearly here, and I believe the intent of the co-sponsors is simply to codify in Rhode Island law the current state of things and get laws that have been found unconstitutional or unenforceable off our books so that people aren't confused by reading them. I am happy to answer any of your questions, and thank you for your time.
Any questions for the sponsor? All right, seeing none, thank you.